Good afternoon. Attorney Protective would like to welcome you to today's webinar, Conflict Zone, Strategies for Ethically Avoiding Conflicts of Interest. Please reference your materials for information about today's speakers, Cal Watson and Kate Gould. And with that, I would like to introduce our first speaker, Kate.
Thanks so much, Erin. And thank you all for joining us today to discuss conflicts of interest. Conflicts of interest problems are far too common because of the frequency you must perform a conflicts check, that being for each new client and every matter, every time. It can be difficult to decipher whether you have a conflict because the rules are complex and can be confusing. For this reason, conflicts of interest remain the most frequently alleged malpractice error, as the statistics we will look at today show. In today's webinar, we will discuss the ABA model rules with respect to conflicts and how to analyze conflicts in general. But as you will hear us say many times, always check your jurisdiction's rules and their comments to ensure compliance in your state. Today, we will actually examine various scenarios with the hope of offering you some real-world examples you may encounter in your practice. We will conclude with our webinar with our top 10 takeaways that we hope will be useful for you, and then wrap up with our Q&A session as usual. So have those questions ready. With that being said, let's jump into the stats. You may be familiar with Ames & Goff, a specialty insurance brokerage. They provide helpful insight and analysis into malpractice claim trends about every other year in their publication, The Lawyer's Professional Liability Survey. Their last survey was released in 2024. Just like the prior survey in 2022, this latest survey also shows that conflicts of interest continue to be at the top of the list of alleged malpractice errors. Specifically, conflicts of interest remain the single largest cause of legal malpractice claims, with 9 of the insurers polled ranking it the first or second most common error. These statistics are particularly troubling because these types of claims can be very difficult and expensive to defend. In general, juries don't like when lawyers breach their duty of loyalty to their clients, which is really the underlying issue with a conflicts case. This can mean large verdicts. What's more, punitive damages can be awarded in a legal malpractice action due to conflicts in some jurisdictions, meaning a very costly claim. This drives home the point of how important it is to not gloss over the conflicts check. However your firm handles the conflicts check, whether a report generated by your case management software and/or an email circulated around the firm with a potential client and matter, carefully and thoroughly review the new client matter or client relationship for any potential conflicts. I know it's easy to disregard that email and the flurry of emails that we receive each day, but you may catch something or identify a relationship that the system did not flag as a potential conflict. As we've recently learned with the AI cases where attorneys fail to verify the actual cases they cite in briefs, having that human touch is critical. Also, keep in mind that conflicts checks should be performed when considering a lateral hire as well. Ames & Goff reported that the inappropriate handling of lateral hires was an area of concern when it comes to conflicts. We'll take some time to specifically address this later in the presentation. With that, let's jump into the rules. Cal?
Thank you, Kate, and thank you for the opportunity to present today. Just by way of background, my perspective is litigation. But regardless of your practice area, you have to make sure that you do not take on a matter with an unresolved conflict. This applies whether you do family law, estate planning, corporate, tax, any and all practice areas of the practice. The first stop for any conflict analysis in your jurisdiction is the rules of professional conduct that have been adopted by your jurisdiction. All of the states and the District of Columbia have adopted the ABA model rules of professional conduct. But as I mentioned, it's very important to check for any variations in your state or your jurisdiction's rules. In some instances, states can add or revise the model rules to reflect some local practice or custom that might be unique to that jurisdiction or state. I practice in South Carolina, and our model rules of professional conduct have a few different requirements than the rules in other states and the model rules. As we move through today's webinar, we will refer to several rules that are important to any conflict analysis. And if you look on your screen, the rules are listed there. And as you can see, the rules are basically divided into 4 different categories. 1, rules that address issues with current clients. Rules that address issues with former clients. Rules that address how and when conflicts are imputed from one attorney to another attorney. And then rules that address prospective clients. We'll go through these rules in detail today, and we'll discuss some real-life scenarios. But in the meantime, it is important to know where the rules are and what situations they address. I'd also encourage you to look at Rule 1.0, which contains the definitions. In the rules we'll talk about today, you'll see over and over the phrases or terms informed consent, reasonable belief, writing or written, and consult or consultation, and many others. Believe it or not, these words and phrases are defined in Rule 1.0. So as you look at the pertinent rules, don't forget the definitions, because sometimes these definitions can give you guidance and may even impact the outcome of a conflict analysis. And finally, any conflict analysis, regardless of your practice area, is essentially the same few questions. Number 1, who are the affected clients? Does a conflict actually exist? If a conflict actually exists, can it be waived? And if so, are the affected clients willing to give you that very important written, informed consent to proceed with the representation in spite of the conflict? So with this as our backdrop, I'm going to turn it back to Kate for the first scenario.
Great. Thanks, Cal. Here's the first set of scenarios we mentioned we would review: relationships with opposing counsel. Scenario number 1 may look familiar to you. If you live in a smaller legal community, chances are you may be practicing with law school classmates who have now become colleagues. The question is your relationship with opposing counsel a conflict? Under this set of facts, there is not a conflict under the rules. However, you have to evaluate each situation on a case-by-case basis. If there is a risk your representation of your client will be materially limited by your friendship or relationship with opposing counsel, you have a conflict. This is Rule 1.7A2. It's worth citing ABA Formal Opinion 494 here, which addresses friendships. It states that close friendships should be disclosed. And what does that mean exactly? If you exchange gifts, spend time at each other's homes, or vacation together, you probably have a conflict. In contrast, if you're just law school classmates or have a casual friendship or acquaintance, you don't have to disclose those relationships. Now, scenario number 2 on your screen is a completely different situation. And hopefully this is obvious, but if you become engaged, you would have to give the case up to someone else in your firm. The rule implicated here is also Rule 1.7A2, which I just referenced, which prohibits lawyers from representing a client where the lawyer's representation will be materially limited by a personal interest of the lawyer. Here that interest is clear. Keep in mind, this is a two-way street. So if your significant other should likewise be performing the same conflict analysis. Keep in mind that because this conflict is unique to the lawyer, not the firm, it could be cured by handing the case off to someone else. In general, when considering similar conflicts like this, you have to examine when the nature of the relationship creates a conflict of interest, requiring the lawyer to take steps to address it. Comment 11 to Rule 1.7 specifically identifies a personal interest as when a lawyer is closely related by blood or marriage. Under such circumstances, the attorneys cannot handle the case unless informed consent in writing is obtained from the client. Again, the analysis really turns on the nature and closeness of the relationship or friendship. The ABA categorizes the relationships as either intimate, a friendship, or an acquaintance, if that's helpful for your analysis going forward. And if you're questioning it, you may also wish to hand the case off or just decline the representation at the outset if your relationship with opposing counsel would even create the appearance of conflict that you want to avoid. Cal, do you have any further thoughts on this one?
Yeah, this is a tricky one because the legal profession in many places is very close-knit, particularly in smaller towns and smaller communities. This could be an issue that would be something that you should think about as you take cases. I would say that Rule 1.7A2 that you mentioned is the rule we should go to and think through about whether there's a significant risk that your representation would be materially limited by your relationship. And, it's a tough one. It really is. But as a general rule, I think that that these relationships are important for the civility for nothing else. So this is a tricky one. Let's move on to the next scenario. This one is investing in clients. And you can see on the scenario that you've assisted your client in developing a business plan for a startup company, and as a way of thanking you, the client offers you some shares of the company. And the question is this a conflict? There are really several different ways this scenario could go. If the shares are being given to the lawyer as part of the legal fees the client owes the lawyer, then Rule 1.5, the rule on fees, should be considered. If the shares are being given as a thank you gesture and not for the payment of fees, then Rule 1.8C likely applies and might even prohibit the transaction. If the lawyer is planning to continue as the counsel for the new entities while holding the shares, then Rule 1.8A and the comments set out the process to follow that could allow this transaction to happen. Regardless of which way this scenario goes, I would be really hesitant to receive these shares without another lawyer weighing in on the fairness issue. This is a tricky and complicated issue. It definitely merits reading Rule 1.8 very carefully. There are many pitfalls that are at issue when lawyers receive shares or go into business with clients, and in my opinion, they are often just not worth it. Kate, what do you think about this?
I agree. This scenario makes me nervous as well, Cal, and I think your comments about seeking independent counsel are well taken. I mean, obviously the rule requires you to advise your client in writing about having another lawyer look at the transaction, but you really should encourage it too as a means of protecting yourself and your client. So send the letter, but also follow it up with a phone call, just as a practical matter, so you can reiterate the need to have someone else look at it and answer any questions that your client might have.
Let's move on.
We're next going to move to social media and technology conflicts. This category of potential conflicts will continue to challenge lawyers as technology and the way we interact with each other on social media evolves. As part of your firm's marketing plan, you may be asked by your firm to write blog posts, or perhaps you have your own blog that's not associated with your firm. Either way, the nature of the information contained in your blog will determine whether you have a conflict in an ongoing or future case. In this scenario, you wrote a blog post on your firm's website about what to do if you were sexually harassed in the workplace. A lawsuit is filed against a company that your firm represents, and the plaintiff employee that was fired tells their attorney they relied on the advice from your blog when they reported the harassment. The question is your firm conflicted out of representing the company in this case? Here it would depend on whether the plaintiff's reliance on what you said in your blog would materially limit your ability to represent the company client. Unless it's a critical issue in the case, probably not. The company and your firm finance committee will be happy you can continue representing it. However, be mindful of the best practice tips we have listed here on this slide. Whether in a blog or a response to an online inquiry, avoid giving any specific advice or expressing your legal opinion. And in general, whether online or in person, avoid that "I know you're a lawyer and I have a really quick question" scenario. That should raise a red flag in your mind because of the potential for conflicts. Disclaimers are also critical when posting online content because they will hopefully prevent you from creating an unintended attorney-client relationship. As always, be sure to check your jurisdiction, especially with regard to disclaimers. As long as your online conduct is consistent with the disclaimer, you could potentially avoid a claim. Kyle, do you have anything to add to this one?
No, I think those are great practice tips, and this is an important issue, particularly in today's world.
Yeah. Okay, good. Yeah, it's just an area with a lot of pitfalls, as they all seem to be. Let's move on then to the next scenario, litigation finance. The question posed here is whether the fact someone else or some other entity paying your client's bill is automatically a conflict. The answer is no, not automatically, but a few rules come into play here. First, Rule 1.7A2, as we have discussed previously, is at issue. The personal interest here is the firm's financial position. The lawyer has to ensure that payment of its fees by the litigation funder does not in any way materially impair their ability to advise the client to consider a course of action that may not be best suited for them. In other words, you need to avoid the situation where your interest in resolving a case to collect a fee does not affect your duty of loyalty to the client. Next, the model rules concerning your independent judgment come into play. Rule 2.1 of the model rules commands a lawyer to exercise independent professional judgment in the representation of a client. Also, Rule 5.4, the professional independence of a lawyer rule, broadly prohibits permitting a person who pays the lawyer to render legal services for another to direct or regulate the lawyer's professional judgment in performing those services. And finally, Rule 1.2 mandates that the lawyer shall abide by a client's decision whether to settle a matter. To meet these obligations, write a letter to both the client and the funder, confirming, among other things, that is the client and not the funder from whom the lawyer will take direction on key strategic decisions, including, and most importantly, the decision on whether to accept a settlement offer. Finally, our duty of confidentiality under Rule 1.6 will of course be an issue, as the funder who's footing the bill will likely think they should have unlimited access to all attorney-client communications. To comply with this rule, the lawyer should confirm each specific category of information the client has voluntarily authorized counsel to disclose to the funder, including ongoing reports to the funder of material developments in a matter in a letter. And as a reminder, as I ticked off about 4 different rules here, read the rules, but also review the comments. And that goes for the ABA model rules and your state rules. Particularly for the model rules on conflicts, the comments can be really helpful in determining whether you have a conflict. You'll notice how lengthy they are in compared to the actual rule itself. Cal, do you have anything to add to this one?
No, that is a tricky area, but I think you covered it. Let's move on to the next scenario. This is the one that Kate mentioned earlier, involving lateral partners who join your firm. And in this case, a conflict is discovered after the partner joins the firm. In the real world, this conflict should have definitely been identified before the lawyer arrived. So before we get to the conflict portion of this, it really goes without saying that you should always check conflicts while you're interviewing a lateral before the lateral partner joins the firm. And when you do that, you can either work out conflicts or determine that potential conflicts could be a brick wall and you should not move forward at all. And from a risk management standpoint, you should always make sure you inquire about the lateral partner's problem files. I mean, are there red flags associated with any case or transaction the potential lateral partner brings to the table? Has a client questioned the way a case or transaction has been handled? Has the court issued sanctions or warnings to the lawyer? These are the types of issues you really need to have a frank and open discussion before a lateral partner joins the firm. But getting back to this scenario, if you do discover that the lateral partner represents in this case, a co-defendant in a wrongful death case to which your client is adverse, you should look at Rule 1.7. Assuming the representation is directly adverse or there's a significant risk that the representation of the client could be materially limited by responsibilities to the new client, these are the analysis points in Rule 1.7, you would then have a concurrent conflict of interest. At this point, if the lawyers reasonably believe that the firm can competently and diligently, and those are the words in the model rule, represent both clients, the representation is not prohibited by law, and the representation is not in the same proceeding, then and only then you can seek a waiver from the clients. And that waiver, as we've mentioned, must be informed consent and in writing. If both clients agree, then you execute the waivers and you proceed with both representations. If both clients don't agree, then you have another series of issues, but we'll get to that circumstance in one of the scenarios we'll get to in a few moments. Kate, do you have any thoughts on that one?
Yeah, I think I agree with your comments, and I would caution everyone to review these best practice tips. Lateral hiring continues to be an area where malpractice can occur. I think firms can, even aside from the conflict issue, get kind of lulled into thinking, okay, we have an experienced lawyer coming over. It doesn't require the due diligence. Maybe we don't need the oversight where we would spend it on newer associates. But I just would caution everyone to, develop a protocol for lateral hiring, including an extensive and thorough conflicts check, and just be, wary of all of the potential pitfalls with lateral hiring. I think we're still seeing a lot of lawyers on the move, so it's been an issue that has come up quite a bit in the risk management world.
And the key is it all needs to be done beforehand, not after the lateral attorney joins your firm. I think that's
absolutely, yes.
That's the best takeaway from this scenario, because there can, as Kate mentioned, there can be a number of problems. Let's move on to the next scenario. I think Kate's going to handle that one.
Yes. So our next scenario is scenario number 6, conflicts arising from serving as a board member. And here, a senior partner at your firm is on the board of a local homeless shelter. Your local bar association refers a pro bono matter to you as part of its volunteer lawyer program to represent an individual who alleged they suffered a broken ankle when they tripped in the shelter. Does the partner's position on the board create a conflict of interest? Should you refuse to accept the case? Does it matter if you're handling the case pro bono. And this is a classic issue conflict. As a board member, the senior partner has a personal interest. Under Rule 1.7A2, a conflict could exist because of the significant risk that the representation would be materially limited by the lawyer's personal interest. Whether the lawyer's personal interest rises to the level to materially limit the representation is again going to be evaluated on a case-by-case basis, but the optics here are not good. It's probably best to decline this one. And note the law school essay question red herring here. The fact that you would be taking the case on a pro bono basis makes no difference. Cal, would you agree with that analysis in this one?
Sure. Yeah, and I'd also just emphasize that it is a case-by-case situation. I don't think there's one hard and fast rule that applies here, but it is worthy of note when these situations occur.
Okay, great. We're going to move on to the next scenario. Cal, are you taking that one?
Yes. Let's look at this scenario. And as you see, it details a conflict among current clients, but it's a conflict that can be waived. So this presents the classic question of whether a lawyer or a law firm can dump one client in favor of a more profitable client. I think this is a scenario that often arises. In this case, as you'll see, a one-time post-judgment collection case is the only thing standing in the way of a larger, much more lucrative new matter. As an initial matter, this situation does create a conflict under Rule 1.7, very similar to the scenario we just talked about. The firm would, in this case, represent two clients who are directly adverse to each other in a proceeding. So for purposes of 1.7, it doesn't matter if the representation involves different matters. It still presents that concurrent conflict. But in this case, the conflict can be waived by following the procedure that's outlined in 1.7b, assuming that all of the subparts of 1.7b are met. You should really look at these subparts very carefully when considering whether a conflict can be waived. But here, I think the two representations are so different, I would submit that this is easily and definitely a waivable conflict. And as a waivable conflict, these lawyers should then go through the process of a waiver by informed consent confirmed in writing, just as the rule requires. So I mentioned in a previous scenario what happens if one of the clients does not agree to waive the conflict. One option is to seek a different lawyer in a different firm and substitute counsel with the client's consent. And that would be one way of resolving the conflict and moving one case to a different firm. A second option is to consider terminating the representation pursuant to Rule 1.16. That rule allows a lawyer to withdraw as counsel if the withdrawal can be accomplished without material adverse effect on the interest of the client. Of course, this process requires a motion and permission by the court, and if the court orders that you continue representation, then you must comply. But this type of scenario is discussed in detail in Rules 1.16c and 1.16d. In short, I think in this case, you can accomplish your goal of set out in the scenario, and the easiest path is a conflict waiver or a consent substitution of counsel, but all hope is not lost if those scenarios or those options are not available. Kate, what are your thoughts about this one?
Oh, I'm sorry. Can you hear me now?
Yes. What are your thoughts about
good.
this scenario?
Yeah, I think this one brings up an important issue when you do a conflict analysis, and that's whether if you can waive it, and the possibility of securing a waiver so you can proceed with handling the case. Do you have any practical guidance about moving forward with a waiver and how you would complete that with your client, Cal?
Yes, I mean I think the more transparent you can be, I would overstate the conflict. I don't mean that in the way that it's not transparent, but state it in a way that it's very clear and obvious what the conflict is and what a waiver means. I sometimes will urge the affected client to seek independent counsel to check behind and make sure that the waiver could be deemed informed consent. But at any rate, it always needs to be in writing.
Let's move on to the next scenario.
Okay, I'll take this one. This one involves prospective representation. And you can see in this scenario that you've discussed a potential client's case in a very general way, no agreements reached, and then you were later contacted to represent the opposing party. And this is exactly what Rule 1.18 addresses. And the bottom line to Rule 1.18 is that you can have a general conversation about a case and then take the other side of the case. What you can't do is receive information from the prospective client that could be significantly harmful to that person in that matter, and those are the exact words of the rule. This is the reason that you should, as a matter of practice, receive only general information that you can use to determine whether or not to take the case. A key question in this scenario is, how much information did that first lawyer obtain? If it's just a very general overview, then a second lawyer can take the case in the firm. If the first lawyer went into great detail with the prospective client, then there could be an issue. But even if you did receive some disqualifying information, another lawyer in your firm can take the case so long as you're walled off and not apportioned any part of the fee. And that process and protocol is detailed in Rule 1.18. Now, the second part of the scenario on your screen are a couple of questions that present some interesting twists. As far as the first question, whether the first lawyer has not yet declined the representation in writing, I don't think the existence of a letter declining the representation makes a substantial difference in our analysis. The best practice is by far to have this letter in your file, but the analysis really turns on what type of information you obtained. This, of course, assumes that you didn't assume the representation in your interview. And in that case, we're under a different rule, and all bets are off for prospective representation. My response to the last two questions is that you should assume that the information you received is an issue. And in that case, you could be walled off and not apportioned any part of the fee, and your firm could still handle it. But you just need to make sure that these safeguards are in place and that the information you obtain is not disqualifying, is just a general overview that gives you an idea of whether or not you should move forward with the case and whether or not a conflict is present. Kate, what do you think about this one?
Yeah, I would agree with your comments, and I think there certainly is, there are parameters to what information you can receive in that intake meeting, but there's also an art to it. So I would just encourage the young lawyers listening to sit in on those intake meetings and learn what's appropriate, what information you can receive from a prospective client, and what may be stepping over the line and prohibit you from taking the case from the opposing side in the future if they would contact you. You mentioned the non-engagement letters. We actually have some form letters on our website. We have a non-engagement letter actually specifically for a conflict of interest. And I think, this can be sometimes a step you can overlook. So if you need a form, check out our website, compare it against your form non-engagement letter, and just be sure to send that as part of your procedures. And that helps you just draw that line in the sand. Hopefully you don't need it, but it's there if you do.
Yeah, it makes it crystal clear that you've declined the representation and you don't have to get into the what ifs here. So that's a really good point, Kate. Let's move on to the next scenario. This is a tricky one. The issue in the next scenario involves using an expert in one case and then opposing the same expert in a different case. So in many practice areas, there's such a small pool of experts that choices are often very limited. My gut reaction in this scenario is there could be a problem if you're limited by how you either present the expert or how you would cross-examine the expert because of your duties and responsibilities to another client in a different case. And if that limitation or restriction you feel meets the standard of Rule 1.7A2, then you could be looking at an issue. Suppose you might challenge the expert's credentials or manner of operational cross-examination. And if you forego that opportunity because it might impact how you use the same expert in a different case, that could be the significant risk that representation of one or more clients will be materially limited by a lawyer's responsibilities to another client. I really think this scenario is so fact specific that it's very, very difficult to give a blanket answer. Presumably, this expert would have notified the other side of his or her association with the first lawyer. But this is definitely food for thought, and it does illustrate the second part of Rule 1.7A. Kate, do you have any other thoughts on this one?
I would agree. This is a tricky one, and in many practice areas, there's such a small pool of experts that the choices can be very limited. And so I would agree, there could be a problem if you were limited by how you either present the expert or cross-examine them because of your duties and responsibilities to another client. If that limitation meets the standard of Rule 1.7A2, which we've cited many times during this presentation, there could be an issue. If you challenge the expert's credentials or manner of operation on cross-exam, if you do that, you could forego those opportunities because it might impact how you use the same expert in connection with a second client. And that can trigger the rule and create that significant risk that representation of one or more clients is materially limited by your responsibilities to another client. To state the rule yet again, like you said, I think this scenario is going to be very fact-specific, so it's difficult to give a blanket answer. I would agree with you on that. And presumably the expert would have notified the other side too of his or her association with the first lawyer. But I think it does illustrate that second part of Rule 1.7 that we've discussed.
Yeah, and this just illustrates the idea that it really does take some analysis because there are very few blanket answers in this field. So this scenario of all scenarios shows how it could go a lot of different ways depending on very specific facts. All right, let's move on to the last scenario. This last scenario involves a former representation. And the rule at play here is Rule 1.9. And in this case, as you read this scenario, a lawyer represents someone in a divorce action, and then 3 years later, the same lawyer is asked to be adverse to a company, and his former client serves on the board of that company. And the question is this a conflict? I would submit the answer to that is no. The second matter is not the same matter, and it's not substantially related to the divorce action. And the former client is merely on the board of the adverse party and is not the adverse party himself. I don't really see any problem with that representation. It could get trickier, though, if we change the facts a little more and assume that the suit at issue involves the former client on a guarantee. And in that case, the lawyer should really consider very carefully whether he or she obtained financial or other information in the divorce that could be used against the former client in the guarantee suit. If the lawyer obtained information that is not public, Rule 1.9 prohibits a lawyer from using information relating to the representation to the disadvantage of the former client, even if the matters are not related. Again, this is another example of no blanket answer, other than it depends, and depends on specific facts. It also depends on the information that was actually obtained in the first representation. And I'd also say in this case, the passage of time, 3 or more years, can make a difference because financial information can change substantially over the passage of time. Food for thought, but it illustrates the issues you might face with a former client. Kate, do you have any thoughts on this one?
Yeah, I was going to ask you whether you felt that like the 5-year time difference, really would impact your answer to this.
And my answer to that, or my response to that question is I think it does. If we're talking about financial information and 5 years has passed, depending on a lot of other circumstances, that 5 years can make a big difference. Things change over 5 years. Things become less relevant over 5 years. At the same time, other things don't change over 5 years. Again, this I think illustrates the issues that are out there with no blanket answers. It's very fact specific, and I think you'd have to do an analysis on these particular issues.
Sure. I'd say too, as a practical matter on this one, this scenario really drives home the need in general for that final disengagement letter and the importance to be able to categorize a client as a former client, because in this scenario, you're able to trigger Rule 1.9 duties to former clients. And again, I have to plug the Attorney Protective website. We have form disengagement letters. If you want to check your form against ours, obviously use our form as a basic outline and then develop your letter and tailor it to your case. But again, make sure you're able to document that the individual is now a former client. And with that, we're going
to... I was just going to add,
go ahead, Cal.
That is just to compare the requirements that we've talked about with Rule 1.7, which is current clients, versus the requirements of 1.9 of former clients. Big difference, and much the restrictions and responsibilities under Rule 1.9 are much reduced from 1.7, which makes that end of engagement letter even more important. So you have that bright line of this client is now a former client.
With that, let's move into our top 10 takeaways.
You want to take number 1, Kate?
Yeah, I'll take number 1. Like you've heard us talk about throughout this presentation, the best way to start your conflict analysis is to start with the rules. Like Cal mentioned, the ABA model rules have been adopted by every state, but it's important to check your state model rules of professional conduct for any state-specific additions or modifications. You don't want to make the mistake of citing to the general ABA rule when your state rule is going to be a little different. And I think it's just easiest to go back to the rule each time rather than guessing and trying to remember what do the rules say. Apply the rule specifically to each conflict you need to evaluate.
And the only thing I'd add to that is these rules of professional conduct are everywhere. They're available electronically 24/7, so you have them at your fingertips at all times, and it's unlike the days when you had to go pull them out of a book. Our second takeaway is review the comments that follow each rule, and I can't emphasize this one enough. The comments really give a lot of guidance and direction to the rules, and they talk about scenarios, they address scenarios, they address issues that you may not have thought of, and they're very helpful, and they are far more detailed than the rules themselves. But the comments are really add a lot of flavor to the overall analysis. So I'd urge you, when you determine what rule applies, or whether you're talking about a current client, former client, prospective client, and you know what rule you're working with, then look at the comments, and you'll get a lot more information that way.
I would absolutely agree, Cal, and I'm always surprised when I look at the comments to the rules how much detail they go into the scenarios, because you can very well find a scenario that you may be dealing with that's actually really explicitly explained in the comments. Our next takeaway is concerning engagement letters, and having that initial engagement letter define your client and the scope of your representation is crucial and really sets the tone for the representation, and is also so helpful should future potential conflicts arise. Knowing who you represent and the scope of that representation may save you from a conflict in the future. So while we have some forms again on our website, make sure that you're tailoring that to your practice and the specific clients.
Yeah, I agree with that 100%. Our next takeaway is that end of engagement letter that we just mentioned really just a moment ago. And I can't emphasize again how important it is to, if you can do your analysis under 1.9 versus 1.7, and an end of engagement letter puts that bright line between current client and former client. So make sure that you make that part of your practice. And as Kate mentioned, I think there are samples on the website.
And on the other end of the spectrum is tip number 5. If you decide to decline to take a case from the outset, make sure you inform that prospective client in writing. Send the letter. There's no, you certainly just don't want to risk creating an attorney-client relationship by not clearly stating that you've declined the representation, and even explaining that you do have a conflict. You can discuss it over the phone or in person, but as we all know, if it's not in writing, it didn't happen, make sure you send that letter.
I couldn't agree more. Our next takeaway is, if you seek a waiver, go overboard in explaining the conflict and put everything in writing. This is what I mentioned just a moment ago, and that is to over-describe the conflict and make sure that it's written in a way that there can be no doubt later on that the client was informed about what the conflict was. And as I mentioned, I often urge the client to seek independent counsel to advise them on whether or not to waive the conflict. And often clients don't do that. In fact, in most instances, they don't. But I think it's a nice addition to a letter where you over-describe or go overboard in how you describe the conflict. Kate, you have anything to add to that one?
No, I agree. I think, like you said, best to just over-describe, go overboard, say more rather than saying less, for sure. On our next tip, we talk about taking advantage of external resources. And if you're having difficulties determining whether you have a conflict, be sure to reach out to your state or local bar or the AppPro Risk Management Hotline. These bars have ethics hotlines, online resources that can be of assistance in helping you evaluate conflicts. You may have a colleague that you can discuss it with inside or outside of the firm. I mean, it's best to do the thorough and full analysis before you take the case. And if you're questioning it, don't hesitate to seek out those resources.
No, I agree. And as I mentioned, there are many, many resources out there, and I think that's a great takeaway. The next one is remember the definitions in Rule 1.0. This is what I said at the very beginning of my comments. Several of the very important phrases you've heard us say them throughout this webinar, like writing or written or informed consent or reasonable belief. All those things are defined in Rule 1.0. Can give you lots of guidance, direction, and it may be defined in a way that is not your understanding. So as you go through this analysis, make sure you have a good understanding of what all the pertinent words are, and these are found in the definitions in Rule 1.0.
I agree, and I think you'll find, throughout the various jurisdictions that 1.0 is always going to be your definition section, so easy to find, and check out the definitions of those words that you may not even think are defined. They can be helpful. Our next tip discusses just what I mentioned about potentially talking to a colleague who can help you conduct the conflict analysis. Since some of it does involve your reasonable belief, bounce it off somebody else. There's no shame in doing that. We're all used to that reasonableness standard, and it's helpful just to use a colleague as a sounding board to ensure you don't have a conflict.
That's really good advice. And even if you practice in a solo situation, have a trusted friend who doesn't have a dog in the fight, and that person can give you a very objective view as well. Our final tip is if you go through the analysis under the rules, you read the comments, you talk to your colleagues, you call the bar hotline, you read the publications, you look at all your external resources, and you still think you still don't know whether or not you have a conflict, err on the side of the decision that you do have a conflict, because if you go through the analysis and you cannot make that determination, you really likely have a conflict, and if presented to a court, the court may have that same view as well. So in those cases, I would err on the side of declining the representation or declaring that there is a conflict.
Yeah, that's great advice. If you think you have a conflict, you probably do. Absolutely.
And with that, we'll turn it back over to Aaron for our Q&A.
Great. Thank you so much, Cal and Kate. Such good points here, especially because, as you both have been saying throughout the presentation, conflicts are hard to identify. So thank you so much for this presentation. So with that, we have a lot of great questions coming in. The first one I'll take is the attorney-client relationship waived when the client authorizes communications between the attorney and a third-party funder?
I'll take that one, Cal. I think this is really more of a question of privilege versus conflict. And of course, you could it's easy for the client to waive the privilege if they are going to authorize those communications. We kind of talked about this during the presentation. I think it is important at the outset of the case just to be specific about what information will be shared with the client and what information will be shared with both the client and the funder. So the expectations are clear from the outset. Would you agree, Cal?
Yeah, and I do agree that this is more of an issue of privilege rather than, I think, conflict. It's more of an issue of whatever the applicable case law in your jurisdiction is. I think the case law on privilege is fairly consistent across jurisdictions, but there are differences. And, I think as a general rule, privileged communication that's shared with a non-client in the absence of some sort of joint defense agreement, can be a waiver. I think we all know that courts have made all sorts of exceptions to that general rule. So I would urge this person who asked this question to do the research in their jurisdiction just to see if there are exceptions that might apply. But, to be on the safe side, you might assume that it is not protected and kind of work backwards from there. That would be my thought.
Great, thank you. Another question that we have is, generally, does a lawyer's representation of a company automatically impute a conflict as to each individual employee from that point forward?
I'll try that one. I think that's really a great question, and this actually involves a rule that we didn't cover today, which is, I think that's Rule 1.13. And it's the client, if a client is an organization or organization as a client. I think the duties of a lawyer under Rule 1.13 run to the organization, but because the organization acts through others, then the duty runs to, I think, officers, shareholders, the people who are communicating on behalf of the organization. But the responsibilities of the lawyer are directed to the organization, as opposed to a specific employee who might not be involved in any way. I think that in this case, assuming that this representation is ongoing, I think I'd treat this as an issue conflict under Rule 1.7. And by that I mean, is there a significant risk that your representation would be materially limited by your responsibilities to another person, and that other person would be the employee? So again, we've said it many, many times throughout this presentation, it may depend on the facts. If that employee was a important part of the representation, and the lawyer felt like the obligations to the organization might be materially affected, then there could be a conflict. But I do think that for whoever asked this question, it's worth reading that Rule 1.13.
Great. Thanks, Cal. So we are 1 minute past the 60-minute mark, so it's not necessary to remain on the line for the rest of the Q&A to receive credit. So with that, I'll ask one more question, and this is one we get asked a lot about on our risk management hotline at AppPro. So I will ask, I always cite the statute of limitations in my declination letter. Is this a bad idea?
I'll take that one, Erin, because I do feel this question quite a bit. We always advise against specifically stating the date that the statute runs. That could be construed as legal advice down the road. There's the risk that somebody relies on that date and you calculated it incorrectly. So you don't want to create that potential problem for yourself. I think it's fine, though, to note that there is a statute, that there is a deadline, that the time for filing their lawsuit is unlimited, but I would advise against specifically citing a date. Would you agree, Cal?
Absolutely, yeah, absolutely. Couldn't have said it better.
Great. Well, at this point, we are out of time for further questions, and that concludes today's event. Certificates of attendance will be emailed to participants within 1 week. And on behalf of Attorney Protective, I would like to thank all of you for joining us for today's webinar. And I would also like to thank our speakers, Cal and Kate. So thank you so much, and have a great day.
Aaron, I'll add, I'll answer this one because I sort of touched upon it on one of my Kate's examples, right? So the short of the answer is no, right? I think, you're allowed to bill for, if you're in a novel area or motions for summary judgment or motions in limine or case specific. But if you're getting a case like in the one that I talked about from Oklahoma, a criminal defense case, and you don't know anything about the criminal law, you can't really bill to get caught up to speed on something that anyone who will practice in that area knows. So, I do, malpractice defense and tort defense. I can't spend time researching duty, breach, causation, and damage issues, right? So I guess it's kind of a yes and no, right? If it's basic stuff, no. If it's very case specific and it's a summary judgment or motions in limine, of course, that's case specific.
Yeah, Eric, I couldn't agree with you more. In fact, it's fun when Eric and I do this presentation, we always try to find some cases that are great examples of what not to do. And I know Eric talked about a few of those in the beginning of the presentation, but there was one that I had read. It's a few years old, but it was out of Massachusetts. I think it was called The Matter of Fordham. But the lawyer spent something crazy like over 200 hours and charged the client, I think it was over $50,000 for a very simple first offense DUI case. So the lawyer argued, hey, I was only charging $200 an hour. That's absolutely reasonable. There were no issues of false billing. This should be legitimate. And the court said, absolutely not. You charged over $50,000 for a case that should have been a quarter of that. And the lawyer said, yeah, but, I admit that I had lack of experience in handling these type of cases. This deficiency prompted me to spend a lot of hours educating myself, but I didn't do anything wrong with billing because my rates were, they were reasonable, and this is exactly how much time I spent. And the court said, absolutely not. You can't pay yourself for learning on the job, even if the hourly rate is reasonable. So I think this is a good example of how Rule 1.5a works, because this wasn't something so egregious that the firm or the lawyer was charging for bathroom breaks, which is another case that we have seen that actually happened. But this is one where they were charging a reasonable hourly rate, but they were just charging way too much for a very simple case where a typical lawyer practicing in that jurisdiction would have charged less than half of that. So just another good example of how these rules really work in real cases.
If you bill by the hour, what is the recommended unit to use? Are there any ethical concerns about billing in 0.25-hour increments?
Sure, Aaron, I'll take this one too, at least in the beginning. Okay. I think the standard of care in the industry is 0.1. If a client agrees to a 0.25, you can probably do it with the caveat of, I think it does create some ethical issues, because if you charge someone 15 minutes to do something that takes a minute or 2 minutes or 3 minutes, I think that creates some ethical issues. And I'd also be a little concerned if you're on a case where any fee award needs to be approved by a court, because my hunch tells me that a court reviewing 0.25 entries on things that turn out to be much less are probably not going to sign off on those fees and will probably deem them to be unreasonable. So I think the best practice and actually the standard of care is to bill by 0.1 increments.
Yeah, and I would just add to that by saying, of course, you want to outline anything in your fee agreement, right? I have certainly seen firms bill in 15-minute increments, but you want to think of the optics again. If a client is reviewing your bill and they see that you charge them 15 minutes for leaving a voicemail where you didn't even have a conversation with them, but you charge them 15 minutes for leaving a 10-second voicemail, it's not going to look good. So I agree with Eric. I think that charging in the 0.1 increments is probably the best thing to do. You can certainly outline something else in your fee agreement, but always think of the optics because that's a really important piece of it.
Another question that just came in, is it okay to charge for initial consults?
Yes, I think it is. You're permitted to charge for the initial consult, as long as the client is aware of it, right? And again, it's explained to them. And a lot of times, I think practically, most attorneys who charge for the initial consultation fee, it's probably collected right there on the spot beforehand. So yes, like with most things, as long as the client is aware and agrees to it, it is something that you can do.
Okay, great. We'll take one more since we're over the time now. Should you reduce a bill to get paid?
I can jump in first if you want me. Go ahead, Eric. Go ahead. I'll follow you.
Okay, yeah, I think both myself and Aaron kind of talked about this with respect to getting bills paid. I think it certainly is something that can be done. I think it's probably better to try to maybe do it on the front end, right? Like I talked about earlier, giving a small percentage reduction if it's paid within 30 days. But at the end of the day, it's if you're at the end of the case and months into an overdue bill, you certainly are permitted to reduce it in order to get paid. But I think the better practice is probably try to do it on the front end and build in the incentive to the client to pay earlier if you take a 2 or whatever percentage decrease off of the bill if you pay within a certain amount of time. So short answer to your question is yes, you are allowed to. Should you? I think the question says should. That's up to you, but I think best practice is try to build it in to the bill to get it paid earlier.
Yeah, and I would just add to that, Eric, I agree with everything that you said. But if you are going to give a discount, and I think I touched upon this towards the end of the presentation, make sure you're getting credit for any discounts. Even if you had talked about this beforehand, I think it only makes you look good that you're offering something like this. So if you choose to give any discounts for paying your bill within the first 30 days or whatever it may be, whatever you decide to do, just make sure you're getting a little credit for that and that the client's aware that you're offering this discount. And that's not something that all firms do. So whenever there's a chance to make yourself look good, I think certainly seize the opportunity.
On behalf of Attorney Protective, I would like to thank all of you for joining us for today's webinar. I would also like to thank our speakers, Eric and Aaron. Thanks so much. Have a great day.